Oh, There's. Oh, how? I'll be down that end. I'll be stuck. Yeah. Yes. Good. So. We shine and you know. All that other good stuff, then.
I did have to, they did give me a. First year. No. Oh.
And you don't. Because and I'm.
It's about. Yeah. So I started. Yeah, because I was like. Yeah.
Yeah, I show up for all the parties.
This is the part.
Want to learn.
You're walking upstairs.
Yeah. On the back.
It's in like 12
Years.
Just hear about
So that definitely was not a problem that for you. You put that in. About that.
You know how many paperwork? Some people brought their.
Which Sharon?
Same paperwork in the bag.
You need copies, Lawrence?
Well, we may need more copies.
I am going to check. We're out, so Lucy's getting more. Yeah. We're getting more.
Yeah. That's.
Yeah. No.
Good of all.
Sure. Yes. I'm serious. I haven't had this.
So I. What? Okay, that's on my stuff. It's.
Now I just need one.
We have our Zoomers here. Good. 21. Zoomers. Give me a thumbs up. Can you hear us okay? We good? Okay. Whatever. They're bringing some more materials.
Yes.
Almost read it. That's the 972-646-0717. You may know what that is? I got this group up here.
It's the bail bond, right?
The most common response I've got across the board, new agents, old agents, experienced agents. I said, we'd have great, we'd have the panel on the agent hotline. They go, what's that? So one of the things we want to do today is reintroduce everyone to a very valuable resource. We put together a number of years ago, pre-COVID and all that, because we recognize that you occasionally would have quick questions.
That's funny.
I'm not looking at you on purpose. I'm not saying that, but yeah. Occasionally quick questions. And while those of us who are in the office, Marcia and I most of the time, are happy to answer your quick questions. Happy may be too strong. Reality, sometimes we're not available. And so we wanted to set up a resource so that you could contact people, get the information. So who needs more copies? So Lucy got more copies. And so you'll see when we get in here, we talk about the time frame that we have here. That you can do it, but it's more than just having a place you could call. Raise your hand if you need a copy. Now, if you already, this is what you've already got. This is material that's already back there. Sue, you've got it right there.
Okay.
That's what we're talking about.
Okay, thank you.
If you don't have that, two more down here, three more. More than just a place to call somebody and ask a question. It's beginning to understand there's a process here. And I have to be a little careful, and those of you who have maybe sent me a text or email or even asked me a quick question. You get a lot more than just a simple answer. You may ask and say, well, here's what paragraph 61 said. There's so many layers to it, so many variables. That one of the reasons for this resource is you've got agents, experienced agents, who understand all those layers and all those variables and can help you ask questions. And one of the things we'll talk about here, the 6 questions you need to ask before you even ask hotline. That'll help you hone in on things. But it helps you understand, because if you've been in my classes at all, you understand I'm not a fan of memorization. I'm a fan of what? Concepts. Understanding concepts, right? Understanding concepts. if you've got the concept down, you can look at a particular situation and analyze and think your way through it. And that's really important. You don't have to memorize the 23 paragraphs of the Wonderful Family and, all those. You just need to understand the concepts. You need to know somewhere in there it's that. And what that'll do is it'll help you feel far more confident as you interact with your client, and they will see that. It creates a credibility for you with your client that they say, she or he knows this. They know that stuff. And that really makes a difference, because one of the key things in every relationship you have with a client is the trust factor. They've got to trust that you know what you're doing. They've got to trust they can rely on you. That has to be there. If that trust will be there, it makes all the difference in the world on how you help them move through the transaction. So who else needed? Up here? All right, so who needs it? Okay, there we go.
Sorry.
So as we work through this, this is intended to be very interactive. We'll have certain things that our hotline agents, and we'll let them each introduce themselves. So that you'll have a sense of who you're talking about here. Except for Joe, we don't want to know any more about Joe. We know all we need to know about Joe. He's from New York, that's it. That's that.
And he knows how to make a good pizza.
Yes, he does.
A good pizza. Okay, see,
Not too much cheese.
that's good. This is intended to be very interactive. So you can ask questions, give examples, go through it, because we learn from each other in these classes, and and that makes sure that we include the Zoomers so that if they have questions or something that they unmute themselves and let us know. And when we have questions from some of the people in the class, be sure I remember to repeat the question so the people on Zoom can hear what the question is and hear what we're talking about there. But this resource, which we set up, it was not an easy thing to set up. We had to jump through a number of hoops, had to make some decisions about doing this, because there's an interesting balancing act that we have. This group, meaning our shared leadership, and dealing with you. We want to do everything we can to support you and provide resources. But we want to be careful we don't step over the line and become enablers. So that you don't have to think about anything, you don't have to think it through, you don't have to worry about the concept, you just make a phone call. That's not helpful to you, certainly not helpful to us. So we wanted to be sure that as we're providing this resource, it doesn't get in the way of you thinking through the situation and coming up with good answers as you analyze and work through it. And you'll see as we'll get into one of the things here, there are some questions that we'll talk about even before you call the hotline. You need to ask these questions of yourself as you'll work through this. Let's do, I do want our fine panel here to introduce themselves, and let's go ahead and start with Joe right here. Joe, tell us who you are and how long you've been in the business and why you're still here. Your therapy working or not?
Joe Martin's, my license is 02/1980. I've been in the business, been a broker since 1982. Been around a while. He's trying to catch up to Bob, but he's too far gone.
My name is Scott Scribner. I've been in the real estate business, I think about 28 years. So my license starts 04/05.
Marsha Levine, I've been in this office for almost 21 years and mine is 050.
Nick McCoy, been in business, 21 years now, 049. Throw that out there. Yeah, so, no. I do have a broker's license, broker associate, I guess.
Yeah,
That's how I call myself.
Yeah, absolutely. And I'm Bob Baker, and my license is 0120.
When,
I have my broker's license since '67 while I was in college.
I can't believe, next table.
What's flagging?
So, now, what I want us to be able to do here, we're going to talk about some things for each of the hotline persons to kind of talk about some of what they've experienced, some examples. I want us to also be able to ask questions as you work through this. But I also want us to make sure we go through the procedure. Because we're not just casually telling you about this. We really want to emphasize this. You really need to make use of this. Not because we don't want you to go to someone else like Jana, Marcia, myself, or whatever. But you need to be responsible on your own to think through these things, come up with good answers and analyze them. And I understand sometimes you're in the middle of it and it's all hot and heavy and you just got to have a quick answer right then. And so the tendency you're going to ask the question. I understand sometimes that happens. But some other times you've got the time to work through it yourself and deal with it and, find a better way to do it than just ask a question as you work through it. Because, we're seeing some very interesting things happening. Is that a good phrase, Marcia? Interesting things happening out there of what people are doing, creative and crazy and everything in between. And this creates a challenge on you. If you don't have a good system in place where you can work through the concepts of whatever you're dealing with, it gets to be a real challenge. And one of the things that we'll talk about is dealing with that. One of the most common questions I get is, working through the process of things. And I'll ask us is, well, what does your client want to do? And in reality, is many times you haven't had that conversation with your client yet. You can't say, well, I wanted to get all the choices and stuff first before I talk to my client. Well, you probably knew the choice. Let's talk through the concept and work through those. So let's start with Nick. Give us a sense of some of what you're seeing in some of the questions that you're getting, any trends that you find yourself dealing with. Because the concept is whenever they get a call, 90% of every call they get, they can handle. Occasionally we'll get to that next level that's a dispute or a demand or an attorney or whatever, and I get involved. But 90% of the stuff, they've got it. They can handle it and they can go through the process and ask you questions and go through it. So Nick, what are you seeing out there?
You do see still some questions about appraisal addendums. So people are still, I think there's still some hesitancy, even though I think most of them know what to put. They kind of just want that double check.
Yeah.
Of making sure.
Especially with choice to the partial.
Exactly.
Yeah.
So, and just how that adds up correctly, still protecting their client, stuff like that. I do get a lot of questions on, see Joe.
Good job.
Anyway, negotiating questions. Questions on kind of strategy, which, there's not really obviously there's not a form for that, but there's not a set in stone. Well, when this happens, when this happens, or this is your option, it's more of, and it's kind of talking it through. So I do see that it's not anything that can be specified there. I went through the voicemails on the helpline and, have examples of what other questions they have. If a contract terminates, how do we make sure that it's fully terminated? Meaning.
So let's touch on that. That's a great point to talk about. One of our really good agents had a transaction. She represented the seller. And her phrase was, well, It didn't close on the day it was supposed to close. The phrase was that the contract expired. Contracts don't expire. One of the great phrases that Avis Wukosh, former chair of Texas Real Estate Commission, former chair of Texas Real Estate Realtors, broker down around Rock, Georgetown, very, very smart, very sharp. He said, contracts don't die. They have to be killed. Action has to be taken. And to think it expired might cause you to say to your seller, we just had another great offer come in, say, oh, great, I'm done with that one. It's over, it's gone. So I'm gonna do this other one. No. You've got to resolve that first one. One of the little challenges I have causes me to see things in a way that fortunately you don't have to see them. That exact scenario we dealt with, and we had what was going to be a lawsuit. It was a very strong demand letter with attorneys in which we had the seller. And we moved past the closing date. We even moved past what we think of as a reasonable time, which is not a defined term. We were 2 weeks past closing date. Our seller had in fact sent a default with notice to, cure to the first buyer. And the seller did enter into another contract against our advice. Well, the first buyer showed back up. Our seller had entered into a second contract with another buyer. And so the first buyer got an attorney and was moving forward to suing us. In that particular case, the title company also made a mistake. They should not have allowed that second contract, and they did. And so the title company, seller, and us, we all put some money together to essentially buy the second buyer out of the contract. So these things happen. So it's not theoretical. It's not happening. Well, they actually happen. And, it's any one of my big roles, what I do is to keep those demand letters and those disputes from becoming a lawsuit or a traffic claim. We had a really good year last year. It was reflected because we just renewed our errors and omissions insurance, and our premium was actually lower than the previous year because we had zero lawsuits. And because we were able to convert those demands. So when you get a demand or something like that, you send it to us and we work on it and go through the process. So these are not just hypothetical. These are things that we got to work on and deal with. And as Nick points out, is deal with that concept of it. So when you have something that doesn't close, before your seller moves forward on something else, you've got to make sure they operate under advice of counsel. They resolve the first one. And the easiest way to resolve the first one, if that first buyer will take it, is release earnest money to the first buyer. And sometimes the sellers are very frustrated, say, well, they don't deserve anything. Yeah, but you want to sell the house, and here you've got another offer that's better than that one. So to move forward on that one, you really need to kill that person, take care of it. And that's the easiest way to do that, even though when mostly they may not want to.
Well, and most title companies, in my experience, require that form to be signed before they'll move on to anything else. So, but that's not, you can't solely rely on them to do that. You have to suggest.
Yeah. What else do you have?
A lot of stuff on leases, but, oh gosh,
What do you have on leases?
oh, it's random.
Okay.
Yeah, I mean, I wrote it down, but I kind of just skipped past it because there was no way to.
The challenge with the leases is it's small numbers. People don't take it seriously. And yet leases and property management are two of the areas with the most direct complaints. So, because we tend to not pay attention to it, you kind of work.
And what I found is since agents don't do them regularly, they aren't as good at preparing for them as they would be for a regular contract and offer. Going through the resale process or even new construction. I feel like they do leases even more rarely than that. And so since there's not a lot of repetition there, there's not a lot of, hey, I got to keep my antenna out for this situation, this situation, this situation. But, the other thing was backup contracts. I think there's some questions on timeline and procedures on how to do the money option fee, things like that. How those work if it terminates, if it's made primary, how to structure splitting the option and earnest money in those situations to not tie up their clients' funds as much, things like that.
So it's a great point, backup contracts. And I think if you've got a seller, I think the seller should always accept a backup. I think it's a plus for the seller as they're moving forward. Because we know all contracts don't close. Plus it gives the seller a little bit more leverage in negotiating with this first buyer, repair and so forth. They've got a really good backup sitting there. Couple of things on a backup, if the seller hasn't entered into a backup contract, working through the process, obviously the backup contract person knows that there's a first contract. That's why they're in the backup position as you work through that. But the seller is not required to tell the buyer on the first contract that they have a backup. That's confidential. That's something that that seller knows and their agent knows. The seller is not required to give that information up to the buyer on the first contract. They may want to hold on to it until all of a sudden use it in their negotiation, say, well, I don't have to tell you this, but I think you just ought to know. I've got a backup and frankly, it's pretty daggum good. In comparison to yours. So if you want to keep asking me for all these repairs, just got to let you know, I don't have a lot of incentive to work with you. So they can kind of hold that back and use it when they find that it's a good leverage in the negotiation. The other thing is that we do have that Trek promulgated addendum, and it has the language in there of talking about earnest money and options, which got in paragraph 8. But we have in our intranet, as Nick pointed out, we've got the procedure for splitting up the earnest money and the option fee. So if you have the buyer on a backup contract, if the seller accepts your backup contract offer, then your buyer has to pay the option fee and the earnest money right then, not later when they move into the first position they do. Now, earnest money is not a problem because if the backup contract never moves in the first position, they're going to get their earnest money back. I mean, that's an easy thing. But the option fee, whatever the buyer pays, the backup buyer pays in an option fee, they never get it back. They don't move into the first position, it's still gone. So we split it up. So if you were going to pay $200 in an option fee, you pay $10 now, and the other $190 when your backup moves to the first position. And we've got that whole page process and intranet that here's how you do that. Here's the example and whatever. The other thing is the Trek promulgated contract or backup addendum can only be used for the first backup addendum, for the first backup contract. I think we've got one right now. I'm trying to remember who brought it up. That they've got a potential for a second buyer who wants to do a backup. That's legal, but you cannot use the Trek addendum. An attorney would have to prepare that second backup contract addendum. Because the first addendum, the Trek addendum, is only good for that first backup position. So if you want to do more than that, it's going to take an attorney to do that addendum. He would make use of the Trek addendum and would make some tweaking to do it. But it's certainly, there's no legal limit how many backup contracts a seller can have. As long as they're all prepared after that first one by attorneys as you work through that. But it's valuable for you to understand how that backup works because we're back in that role again, that whole mode, not as much as we did a year and a half ago, where we're seeing multiple offers again. And what we're seeing, I can think of 4 in this office alone. First contracts that terminated within the first week. This is happening a lot. So if you've got a buyer and they don't get that first contract, get them into a backup. There's a really good chance that you might move into that first position.
I can tell you, in fact, you will look like a hero.
Oh,
If that first deal falls.
your buyer will love you in that.
Yes, they will. Yes, they will.
As they should, by the way. Now, the other thing about that is you kind of work through because it does happen, fairly often. When you're writing the offer on the backup, especially if that first contract is great, no way for us to know it, but they accept it. That's a great contract and everybody feels really good about it. They're not going to look at your offer as seriously as they would have if it was first one. You might get away with some terms that you couldn't have gotten away with if you were the only offer. So you can really do things for your buyer and that backup that you may not have been able to do in that first offer. So understanding that backup is really key to be able to, and you know how you understand it? Read the backup contract addendum. And by the way, and we've had classes on this and backup contracts have other property. And we'll have some more on that. But we also, you know, going through the process, we're going to go ahead and put some of those things, we've got a whole, I think it's about a 2-page write-up on backup contracts and how that works. And we'll make sure that goes into our intranet and I guess into what else will we put that kind of things on? So I just have access to it. Our YouTube channel, but YouTube is only for video, isn't it?
Yeah.
We're gonna start trying to do some videos if we can find somebody. Jenny, yes, go ahead.
Yeah, I'm not volunteering for that, but, so just some other best practices, just some tips. I mean, you can ask if you're in primary and you think that it's been multiple offer, but yours is selected. It's probably a good idea to ask the listing agent if they have a backup, contract. They can't tell you no if they do. They can't lie to you. But if they say something to the effect of, oh, well, can't tell you that.
They just
Don't do that. So, you know, that's good information for your buyer to know. So maybe they don't ask for as much of the repairs, or maybe they do. Maybe they do the mind or whatever. Anyway. Same thing on the listing side. Well, so I agree with Bob to an extent that you always want backup for your seller. It's always a good idea to have a backup on the seller, unless you think that it might be better to keep that open. And if the first terminates, to go back and get a multiple offer scenario. Again, some sellers will like that strategy. I think presenting that strategy to them, the pluses and minuses of that, as opposed to getting a backup locked in, is a good conversation to have.
That's a great point. Depending on what's going on with your property, it's a great idea, good strategy. Yeah. Marcia, what do you have?
I have a lot of calls about what form do I use for this or for that. Just people, when you don't use things all the time, every day, you just sort of forget what you're supposed to use for whatever it might be. A lot of times it's a agreement between brokers, or it could be an amendment, or it could be a usual answer, which is tell your client to seek legal counsel. Because we can't answer a lot of these questions. Fortunately, there's a lot of things that come through and we're not allowed to interpret our clients and we're not allowed to answer. So a lot of times when we get to what the real question is, the answer is they need to seek legal.
She just made a statement. We get to the real question. When you call, and especially when we were talking a few minutes about the 6 questions you need to ask yourself. When you call, we recognize at some level that you kind of decided the answer you're kind of trying to look for. In fact, one of the things we know that happens is you'll call Marcia and you don't get quite the answer you want, and then I'll get a phone call. I mean, and you're playing that back and forth. So sometimes we have to have some conversation with you to find out what your real question actually is as you work through that. That's why if you ever call the Texas Realtor legal hotline, I get a notice from them that you called. And so I will tend to follow up with you and make sure that that we got the answer to the question and see if we need to follow up on that, because the answers you'll get from the Texas Realtor hotline is pretty generic. Because they make it very clear they don't represent us, they don't have attorney-client privilege kind of thing. So they're kind of quoting some stuff. So sometimes it's a question that we need to follow up and keep going on. So you're exactly right, Marcia. Dig into the questions.
I also get questions about things that are in MLS versus things that are in the contract. So people, if you have the buyer, for instance, or the seller, let's do that. You have the seller and the seller tells you, I want to exclude these items, and you put it in MLS and have it in your listing agreement, but it's not in the contract and it doesn't count. So it's important to remember that just because you have it in those places, if it's not in the contract rules. Sometimes you might have an instance where the commission is less than 3%, our agents, of course, but They may be offering less than 3%, and you may have put 3% on the broker page. Well, I'm entitled to 3% because everybody signed the contract. That doesn't count. Whatever's in MLS is what rules, unless you do something to change that.
In an agreement between brokers, for example. Or you change it before an offer is presented. But all this counts, you know, the buyer's agent is responsible to look in MLS on the day they submit an offer to see what's there. Whatever's there, we can hold the listing broker to. But if the listing broker has changed that offering from maybe 3 to 2, and they did it before we submitted an offer, that's what it makes.
And so we should print that off the day we send an offer.
So you've got documentation.
Now you have documentation.
So if we end up in arbitration, you've got good documentation for that. So what are the other forms, Marcia, that you find yourself challenged with?
Get the appraisal addendum a lot. So just amendments in general, verbiage, asking for verbiage, how do I say this? What do I need to ask for in this instance? A lot of times I'll come back with what does your client want? And there is dead silence because they haven't had that conversation. It's like people want to prepare before they go to their client. And so they want to have all the scenarios kind of in their head, but when it comes down to it, we have to do whatever the client really wants us to do. And sometimes, especially when it is repairs, it can be an uncomfortable conversation with the other side. If you have the buyer and your buyer, maybe they're not an experienced buyer and they have, 3 pages worth of repairs. If they tell you, I want you to ask for every one of these, then that's what your fiduciary duty is, and you have to do that. So that can be an uncomfortable conversation. And a lot of times I'll have people call and have the seller and say, the buyer's agent just asked me for 16 things and we're not going to do that. And I'll say, okay, that's fine. Is that what your seller said? Silence. So a lot of times, I think that it's the agents who get in the way of a lot of things in deals. So, if you play nice in the beginning, I know this sounds kind of weird coming from people play nice, but play nice in the beginning and you build that relationship with the other agent, things will go so much better. Even if something happens and the deal falls out, it's so much better than that animosity that you start out with, because what we tend to do is we tend to push that onto our clients. That buyer's agent, what an idiot, they're asking for all this stuff. Well, we shouldn't be doing that. We should be protecting the client from a lot of that stuff.
One thing I started doing, and this comes from Scott Hartman, is, in a while, it's like, we're the fiduciary. It's our responsibility to do what they want, even if we don't agree with it. So if it's something that I don't necessarily agree with what they're doing, I just simply, an email, phone call, I'm just letting you know that I'm acting in the interest of my client and XYZ. And it goes to your point, Marcia. It goes a long way.
Kind of a little additional on that point that the two young ladies make. The agents who I get the fewest phone calls from are the agents who are able to make sure they get along with the other agent. The agents are working it out together and making this thing work. I don't hear from them because they work through and they solve the problems. They get it because they've established that relationship and they all are on the same team for the clients. So your ability to do that, even when the other side is being a little snarky about it, and you'll have that, move right past it. Don't return in kind. Well, you snarky, I'm going to show you out. One of my agents since we've gone. Gave her that. Was in my office and she was, what? They accused me of being snippy. They said I was a snippy. I said, well, you're snipping with me. Snipping with them. That was part of her personality. She didn't recognize it. Sometimes we don't recognize the power of what we say to people, how it really influences them. So we've got to be really careful as we work through that. What else, Marcia? You want to talk to me about the flood addendum?
Flood addendum. Bane of my existence, the flood addendum. So because the seller's temporary residential lease changed in August, Now paragraph 23 says that, you know, the buyer, the landlord, which is the buyer, has to give the tenant notice about flood notice. We use a flood addendum. This is a problem a lot of times because people don't know that. They don't know that maybe they haven't read the temporary lease lately and they don't know it changed. Or I've heard, well, I know we need it, but I just wanted to get through and get the contract executed and then we'll come back and fix it later. Hear that a lot. It's just really important to come to Bob's classes and stay up on what's happening and pay attention to, you know, contracts that change. Gotten some contracts, you know, the new contracts that came out, I've gotten some old ones where it was completely executed and you might have had the seller and the listing agent will say, well, the buyer's agent did it. Well, if you let your seller sign it, then you're culpable too. It's just as much your responsibility for not catching it, so.
Well, and so let's talk about that floodplain addendum. We think it's going to get fixed. We think the legislature and Light Committee are going to change that. What we've got in the seller temporary residential lease on the second page, paragraphs 21 and paragraphs 22 create a waiver from the Texas Property Code because it's one of the reasons this is a temporary residential lease. It has exemptions from security device requirements and smoke detector requirements. And that language is in paragraph 21 and 22 of the seller temporary lease. Well, paragraph 23, they didn't do that waiver. They're requiring the landlord, who is the buyer, to provide that addendum to the seller, who is the tenant. We think that'll get changed and we'll be good with it, but right now it's there. Now, the consequences, the concept of it is that by giving this notice, and what the notice effectively is saying to the tenant, here's our information we have on any floods and so forth, that's on the addendum. And if flooding happens in this property and your personal property gets damaged, that's what it addresses. Most of the time, these are fairly short time frames, you know, a few days, a few weeks, something like that. Some of them are longer than that. But the challenge here, the risk here is that if the flood happens and the seller slash tenant's property gets damaged, then there's some culpability for the buyer. Now, we have to remember, as Marcia pointed out when we were talking, where the buyer, who is the landlord, gets the information on floodplains. They get it from the seller in the seller disclosure notice. So what's stupid about this is the buyer is getting this information. Thank you, seller, for this information. By the way, here it is. And just giving it right back to you. So there's no right in termination at the seller. If the buyer does not include it in the offer to make sure it's part of the contract and checks off in paragraph 23, that's all they did. If that's not done, even the few days that it's there and something happens, whatever, and the seller's property is damaged, then there's some culpability for the buyer. But we've not had it happen. Since this was in there, we've not had anything happen. We've not had any action, not just us, but nowhere across the state. As I've talked to my other broker friends, it's just not happening. So it's one of those things. Don't ever let it get in the way of the contract. So if you got the seller and the seller's temporary residential lease and the buyer makes an offer and they don't include that, if you're going to counter anyway, then you might remind them to go ahead. We really need that. But if they don't provide it, there's no risk to the seller. All the risk is on the buyer side, and all the risk on the buyer side is if it does enough flooding. So we're not going to, except for the aggravation that it causes for Marcia, as she said, I need that, you know. There's no risk on our side. We certainly wouldn't keep being a contract just because it's not included. And I will tell you, outside of our offices here and in Rockwall, because I've got this same stuff in Rockwall. For all the other companies, I would say 90% of them have no awareness of this addendum, and that it's required if you're using the temporary lease. And we're back seeing a lot of sellers temporary leases again because of both scenarios. So it's one of those things that if you do have the buyer, get the information from the seller and the seller's disclosure notice, and virtually every time you say, have no knowledge, have no knowledge, no, as far as we know, and submit it with the offer and send the other side. You know, no downside to doing that. If you don't end up doing it, and something happens, make sure you have that conversation with your buyer. Because if you don't talk to your buyer about it and it doesn't get done and the flood hits, then your buyer has some culpability there and so do you. So, but other than that, it's not a big deal.
That actually reminds me of something else that's come up a few times is after a contract is executed and they realize there's an addendum missing, just getting that addendum signed as opposed to that in a different way.
Yeah, 1 second, Mike. One of the things occasionally that happens is they go back into the contract and make changes. Never do that. Look at your contract as if it were laminated. Always make any change with the amendment. So to Nick's point, if you're going to add an addendum, that's item number 9 on the Trek promulgated amendment form. Buyer and seller agree, add the attached, and then you'll have that addendum. So that the both parties will sign the amendment, both parties will sign the addendum. And then what you've done is you've added that to paragraph 22 of the contract. And the challenge is getting everybody to sign off on it. Everybody agree, oh, yeah, we got to do that. And what gets added often after the fact is our temporary residential lease. And this is most common. Occasionally there'll be some other addendum. But all of a sudden they realize, yeah, we really do need to sell it to the house. Because maybe it wouldn't happen to us, but some listing agents out there don't actually ask buyer's agent, does your buyer have a house to sell? That can never, ever, ever be the case when you have a listing. You can never, ever receive an offer from a buyer and not ask the buyer's agent, does your buyer have a house they need to sell? My sellers, you always got to ask them. And I will tell you, most agents don't. Ours do. Because, I hadn't thought about that, but you preached about it long enough, so I guess I'll start doing it. But you got to do it. You got to ask it because they don't have to tell you. They don't have to use the addendum. They don't have to tell you. That doesn't have to happen on any level. And it's a bad day when all of a sudden you have to tell your seller, oh, we're not gonna be able to close because you couldn't sell their other house. What house? First, I've heard of that. What's going on here? How come you didn't find out about that sooner? What's happening? So you need to make sure you've done all that stuff way ahead of time as you work through it. Anything else, Marcia, before we go, Scott?
Let's just go.
Yes, Mike, go ahead.
Other than flood water, what happens if other water like a overflowing?
Has to be a flood as defined on that addendum.
I know that, but as far as people's personal articles getting damaged by other than a flood, is there anything that we need to be aware of?
Okay, so I'm not sure I'm clear on your question.
My question is,
Stop.
my question is, everything is fine with the house while they're in there for 2 weeks.
So the seller is still in the property.
Yes.
After closing,
The sellers in the property.
after closing, and what happens? We have a
Toilet overflows, it does damage to their couch and dining room set. and everything.
paragraph 14 of the seller temporary residential lease. Seller is responsible for the property, responsible to fix anything goes bad. So if something happens, it's the seller's responsibility and the seller's responsibility if something overflows, water here breaks, whatever like that, and the seller's property is damaged, that's all the seller's side of the deal.
Thank you.
Because there's a tenant in paragraph 14. Now, there's a little glitch in paragraph 9 that deals with wear and tear and some other casualty laws, things like that. But for the most part, it's going to be totally the seller's responsibility. Well, that's the position we're going to take unless we have a seller in the. Yes, ma'am.
Does the seller then though need renter's insurance because they're leasing back at that time?
The seller should have renter's insurance.
Renter's insurance would handle those damages, not the.
Good, yeah, so it's a good idea for them to do it and in a normal lease situation. Yeah, most landlords will require tenants to have renter's insurance. Yeah, it's a good thing. We don't really address that specifically in the seller temporary residential lease. But I think if you do have, the buyer is gonna be the landlord and got this tenant there, then you might want to put something in special provisions of the lease requiring them to do that. So that, that helps that challenge you got there. Joe, you had a follow-up on that? Or, okay, Larry?
I have a question for Marcia.
Okay, you can stop paying attention, Jimmers, because this is between Larry and Mark.
What language looked like in the amendment about a roof? needs to be an insurance claim that's be filed and not gonna happen during the
I
option
will
period.
direct you, Bob.
And now, his question has to deal with language and dealing with the roof and adjusters and reports, things like that. You'll remember in our last class, we talked about the 6 steps in dealing with the repair request procedures. And we kind of talked about that. Here's the crux of kind of where I think you're going with this. You've got the buyer and we've determined some way, shape or form, maybe the seller says self-disclosure, maybe the buyer's track inspector said, hey, roof thing, maybe a roofer. And so what you're going to do is you're going to ask the seller to replace the roof. You're going to ask the seller to file a claim with the insurance company. You're going to have a conversation about that you should receive the adjuster report. You need to make sure that language is clear, because what happens is a buyer should think, well, I'm going to get a new roof and the seller's insurance company is going to pay for it. Well, you better make sure that's the language that you have in the repair amendment, because if you just presume that that's the case, when the seller's insurance company, and there's some really bad insurance companies out there, when the sellers, well, there are, there are. And so when the seller's insurance company said, no, roof's fine, it's 20-year-old roofs, it's, wear and tear, so we're not gonna do anything, and the buyer's expecting a new roof, now we got a problem. So you need to make sure as you work with that, things like you want to make sure you get adjusted report, but you want to make sure if the buyer's asking the seller for a new roof, it's regardless of what their insurance company does. Now, if you've got the seller, you're doing the other side of this. You're going to say, okay, I tell you what we'll do whatever our insurance company is willing to pay for it. And if they're not willing to pay for anything, then you know what? You just bought a house with a 20-year-old roof. We're not doing anything. So you've got to work through that. The key is, as we talked about in that, steps of the repair amendment procedure, is make sure that we are clear who's going to be making the decision, what it is specifically we're asking for, and who's going to make those decisions as you work through that. Because people are going to interpret these things entirely different. Everybody's got a different perspective about what something means as you work through this. There's no way for us to presume everybody understands the exact same thing, and we see that more in the repair amendments than almost anything else as you work through it. Scott?
I would say what I tend to get are pretty consistent with what these guys are talking about. Sometimes we get this sort of mundane, okay, how many days should I put in here? See HOA documents, those types of things. But a couple of situations fairly recently regarding terminations. And so I had one recently where we have an agent that was wanting to rescind a contract because the buyers decided to buy another house. And so as we dug into it, we found out that, okay, the house, they were under contract. So you can't rescind an offer that's not an offer. It's a binding contract. And as we talked through it, buyer had not tendered the option fee. And so they were wanting to just go, okay, let's go ahead and get out of this and we don't have to pay the option fee. Well, if you don't pay the option fee, then you don't have a right to terminate. So
Under that provision.
Under that provision, yes. But I've had a couple of situations like that fairly recently. Again, other ones are just the appraisal waiver, pretty much what these guys are talking about. I will say just a general comment. I've been very surprised at how few calls that I do get on. As big an office as we have.
That's because they don't know about it.
Yeah.
You can fix today. I want everybody in here to watch me over the next week. You're all out.
The secret's out.
Yeah, and I get it. We were all new agents, and what happens is it's Friday night or Saturday night and it's 8 p.m. and you're trying to get an offer in, and so yeah, and so it's but you don't call the hotline. People will talk to their buddy who tells them, oh, you should do this.
Yeah.
And the hotline is there as a resource. So I would say take advantage of it. And I do think kind of, back to what Bob says about thinking through the process, I think the best scenario is where an agent will read the contract, read it. And when they call the hotline, lay out the facts, but also have a solution. Based on my understanding, here's what I think. And I think that forces us to actually, critically think about what we should be doing. And again, kind of going back to the concepts, just like in this case, great example where there was confusion about, okay, what's really the concept? You have an actual accepted contract, you can't just rescind it. That type of thing. So anyway,
The
just.
difference between rescinding an offer, terminating a contract. Two different set of rules for offers, two different set of rules when you're in a contract. And most of it is in the contract itself, but if you're not sure from a buyer's perspective, look at the correct promulgated form, buyer's notice termination contract. And it sets forth the 8 areas in there that are in the pre-printed text. Now, one of the things that's important about that particular concept that Scott brings up is that your seller needs to understand when they accept an offer, they're giving up these rights of termination for the buyer. When the buyer all of a sudden terminates under the HOA or the seller disclosure or whatever other right in there, sells them, well, can they do that? That's the wrong time to say, well, oh yeah, you didn't read the contract, did you? It's right there, it's in there. So that should have been a conversation that you should have had going through the process. They accept an offer and they know what are the conditions under which they've accepted that offer and what can happen as you work through that.
And Bob, I do think that's important for both of them. As you're working with a buyer, of course, you need to say that your number one out is the option period, but there are other outs.
Yes.
Okay? But you also, when you're working with your seller, you need to let them know that so that they're prepared.
Question, yes, ma'am.
Regarding the, what do you call it, this new build and the rentals.
Do what?
The new builds.
Uh-huh.
And the new builders and the rentals, like somebody wants to buy a house. Maybe he wants to buy right now, live. Maybe down, he's young, he wants to leave, maybe after 1 year he might go. Can he rent it out because
We don't know.
restrictions?
That has, yeah, if it's in a major HOA, the major HOA documents will tell him what he can do about rental. What you can run into a situation like that, many HOAs have a percentage.
Yes.
And so it may be okay right now, but a year from now, when he gets ready to rent it, they may have exceeded the percentage and he can't do it. Now, here's our challenge with major HOAs. You cannot review those HOA documents that you receive under the HOA addendum and interpret them. You can't look at that 60 pages and say, well, here's what this means. You can't, they've got to do it. They've got to call the HOA. They've got to ask questions. They've got an attorney do it. We cannot interpret it because they are not correct documents. You're practicing law when you start going through there and say, well, here's what this means. Here's what you're allowed to do. Here's what you're not allowed to do. You can't do that. And yet it's hard because we feel like, well, that's what we're there for. We're there to advise our client. We're there to help them understand. What you advise your client is, these are the conditions under which you're going to own this property. And anytime you buy a property in a managed HOA, you've got certain restrictions that you've got to understand. If you got any questions about any of them, before you close on this thing, back before you enter a contract, talk to somebody at the HOA. Talk to the people that live there, find out what they're doing. Because it's, some of the restrictions are just horrible. Just mildly.
Another thing is, so
So the answer to your question, we don't know. And we can't stay there about what you say is, this is going to depend on what your HOA says. It's going to depend on what their rules are. Some HOAs establish that you've got to own the property for a year before you can rent it out. So they all have different sets of rules.
Some of these new HOAs is 3 to 5 years ownership before you can lease. it
Yeah,
out.
so they've got different
They got their
restrictions. Sure. So you've got to make sure your client has looked at it, read it, understood it, and has taken ownership based on those conditions.
okay, so it depends on HOA. But sometimes say 11% or something. And
Sometimes what?
sometimes they said, okay, now, like some members are now giving to the investors. So they will not change it later. Like one.
See, an HOA, the HOA subdivision information, all that information can be changed by the board of directors of that HOA. So next month, the board of directors can make a total change there. You know, we were allowing 35% to be, you know, investors, but we're gonna change that to 20%. And overnight, give you a whole different ballgame.
So what happened when they sell the house? Suppose 5 years down the line, he's selling the house. So new person has the same problem that they cannot rent it out or?
We don't know. See, we've got our responsibility. Seller. No. Okay, guys, if the seller sells it later to a new owner, that new buyer is responsible for determining what the HOA will allow. We will, this is important. We get into a lot of trouble when we start representing things to other sides. We will not represent on any level. Here's what the HOA will allow you, the new buyer, to do, and never have that conversation. They've got to do their own work. They've got to have their own responsibility. Their agent has to help them to go through that process. When you start representing that, if you're wrong on any level, not only is it liability, it's bad service to the client. I mean, it's bad service to the other side because they're trusting us. They're like, wow, that's what they told us you could do. And we hear that all the time. Our buyer will get information from the other side. Oh, yeah, you do this, and they're wrong as you work through that. Now, Sue, you got a question?
Yes. I just know, if we know the HOA with some restriction, do we need to disclose it in the MLS?
If you're the listing agent,
Yeah, if I'm a listing.
if you represent the seller and you're the listing agent and you say, well, there's some restrictions here, I think you want to be very careful of putting anything like that in private remarks in my list. You may lead them to believe that's all there is. I say, oh, those are the restrictions. Other than that, I'm fine. I can do whatever, you know. No, I think you've got to be very careful. It's the responsibility of the buyer's agent to advise their buyer to work through that process to determine what they can do. It's not. If, for example, let's say that the buyer wants to put a detached garage, and it's a mandatory HOA. Well, that's going to come under provisions of the mandatory HOA on their own things, in addition to city covenants and setback lines. So there are all kinds of things that come into play. And the buyer in paragraph 6D of the contract objections puts in there that they want to build a detached garage. They may include a blueprint with it and the size of it and all that kind of stuff. It's still the buyer's responsibility to determine if they can do it. And if they determine, find some way they can't do it, they can object to the fact they can't do this. If in the big blank in paragraph 6D objections, if they put in there that they want to build, you know, a detached garage according to the attached schematic, if they find out they can't do it, they've got to make that objection to the seller. And the seller wants to, not required. The seller may say, well, that's what I can do about that. Our seller just can do nothing at all under that paragraph. It's totally the responsibility of the buyer and the buyer's agent to know whether or not this thing that they have put in there said, if I can't use it for this, then I can object. That's all they can do is object. It's the buyer's responsibility to determine if they can do it or not do it. As you work through it. So I would not, representing the seller, I would not put any information in MLS saying here's some restrictions, because they could be led to believe that's it. That's all there is. So when you've got 65 pages of documents, you're going to tell all the stuff that can and cannot be done. That makes semi-sense?
I have-
Yes, ma'am.
So if suppose my buyer wants to buy and then to buy 2 properties from our builder.
You're going to buy 2 houses from a builder.
And the builder is saying you can rent. And then can I put over there in one line over there that the purpose is for rental?
You can put that in paragraph 6D, but it's still the buyer's responsibility to determine.
New build contracts.
I understand. Well, okay, in a new bill, if you can put that somewhere in the new bill, some new bill contracts have a special provision, some of them don't. Some of them, it's really hard for you to find a place you can put it. What you do not want to do is trust the builder that he knows what he's talking about. The buyer can say, well, I know I can use this rental because the builder said so. Builder may be an idiot. I mean, it may not make it sell. It just get it, make it sell, especially if it's a builder sales rep, not the builder. I mean, he's just selling houses.
Yeah.
So your buyer, if your buyer says, well, that sounds good, that's a good start. So now buyer says, I'm going to check with the HOA. I'm going to check with all the restrictions. I'm going to find out what I can and cannot do as he works through the process. Do not rely on what the builder says. And even good builders out there may believe, yeah, that's the case, and they may be wrong.
So check the HOA before signing.
The buyer section, correct. Barbara?
Yeah, one of the biggest dangers, I think, is someone saying, we should be all right doing that. You should be all right doing that.
Yeah.
We get that all the time.
Yeah.
It should be fine. Well, again, it comes back to what Bob said. You need to verify it with the source. That,
Yeah.
way, can we do this?
Yeah, and you know, this is something. I guess we got one of them resolved, so we have still two. One here and one in Rockwall. That involves the exact situation where the buyer thought they could do something and they can't. And one of them, the one in Rockwall, will end up in a lawsuit. Because our agent, and this is not a brand new agent, made the mistake of checking it out and finding out what could be done, and our agent was wrong. And our agent represented to the buyer, here's what, don't represent anything. I've said this before, people say, Bob, ask this, you don't know anything. You don't know anything. Everything you know comes from somewhere else. You always cite the source. You don't know anything. You say, well, here's what said, here's what says, and then let them do the research. You don't know anything. When you start representing that roof, that condition of the property, that foundation, what can be done in an HOA, you're now responsible. And not only is it a liability, it's bad service to the client. The client needs to understand what they can trust you to know and do, and what they cannot trust you to know and do. And, you know, the agents that do a lot of enormous production out there, not in our office, but in other offices, doing it because they're selling. They're just selling. And they know there's certain things that they can help them. And hopefully, most of the time, it doesn't come back and bite them and they get a lot of sales going. We don't do that. And somebody mentioned, we have fiduciary duties to our clients. Hey, Marty, you missed it. Fiduciary duties to our client. And that means that we really got to make sure that when we've got expertise, we know what we're doing, market expertise, subject matter expertise, geographic competency, all of those things to the benefit of our client. And to work through and do all that. It's a challenge. Yes, sir. Joe?
Is the track hotline only for the consumer or is it just for agents?
It's only for agents. Oh, we say TREC. Okay, TREC or Texas Realtor.
This is just.
Okay, Texas Realtor is only open to realtors.
Okay.
In fact, when you call Texas Realtors, 1-800-873-9155. When you call that number, they'll say, if you have a question for the legal hotline, press 1. And what they'll ask you for is your license number, so they can verify that you are a Texas Realtor. Only Texas Realtors can access it, 1-800-873-9155. So that's what you call. TREC has a semi-legal hotline, but you can call TREC as a consumer or as an agent and get information. Even as involved as I am with TREC, and a lot of really good people there, including some of the people that answer the phones, they've gotten much better at doing that. What they're doing is they're quoting you the rules. What we do is go beyond that. You know, we say, let's think through it, let's talk about it, let's give you some advice, let's advise you on this situation. And TREC is very careful as to know, and even Texas Realtor very careful, so, you know, we don't have an attorney-client relationship. You know, we're going to give you our opinion, answer to a legal question. One of the things I always like to do is if you call the legal hotline, the Texas Realtor legal hotline, make sure you get the name of the person you're talking to. I know most of the attorneys there. And so when we follow up and I talk to you, I said, okay, what was your question? What answer did you get? And I'll go, I said, I know that particular attorney. I don't think that attorney would have told you that. Let's talk about your question. Because what happens is, and you do this to us, and you do it to them. You're asking a question to get the answer you already decided you won't. And that's what you're doing. So when you ask the question, what you're hearing is something to confirm what you want. And so when I find out, follow up, I say, okay, so let's forget about the sexual hotline. Let's ask me. Let's go through what you really are asking here to get a really good answer. Yes, sir.
I had a question and I was told they need to seek legal advice, legal counsel, you know. But when you tell that to the client, they always say, well, where do I start? Who do I call? Who do you know? So what kind of resource can we provide?
Okay, great question. Of course, they will have already signed off on the vendor statement policy form. You make sure that you've explained to them, we don't recommend, we don't endorse. And this includes attorneys, lenders, title companies, inspectors, any vendors. We say, we think you should benefit from our set of experiences. We don't think we should just send you to Google and just look some names up or whatever. But they do need to do their own research. Now, for attorneys, we've got a list. Generally, depending on what title company, what the issue is, some of the title company attorneys are very helpful. Charles Kramer, Kelly Milligan. I have not yet met Sam Carter, who's legacy, so I presume he would also be helpful. Large title, Brandy. So those would be,
Going more.
More, yeah, for the Legion. So those would be some good ones to start with. If it was beyond that, then we've got attorneys we've dealt with. I could give you a list of 3. Say, yeah, here are 3 attorney names, you give them a call. And when you call these people, these attorneys, make sure you tell them where they got the names as well. We got it from Joe, Plano. So they've got some sense of why they're calling. And because of the relationship, they'll probably talk to them as you work through it. The nature of the issue will help us determine which attorneys would be good attorneys on the list. I've got a couple of attorneys who are board certified for construction. That if that's the issue, that'd be somebody who would show up on the list. Another attorney who's very good at HOAs, and that'd be an attorney who can show up on that list. And every once in a while, we have someone that we're not entirely sure why they need an attorney's name. And it may be that's the attorney's name because they might be going to take action against us. They're not going to get any attorney. They're not going to get any attorneys. Because we don't want to give them a good attorney who's going to represent them too. Now, frankly, most of the attorneys that we have a relationship with, the very first thing you always do is they do a conflict check to make sure they don't have any conflict with who it is this buyer or person may want to go after. And because of the relationship, they all make sure, I'm sorry, I have to excuse myself. I can't represent you, not against, Kelly and Plano, because we've got a relationship there. They may even be on retainer, probably not. Does that help with that, Joe? Is that kind of, so when you,
That's okay. That-
yes, ma'am.
So when we tell them that they need to seek legal counsel, I think it's really important that you tell your client why you're telling them that. A lot of times I feel like they feel we're just putting them off because we don't want to answer it. But it's important that they understand that, we have to stay in our lane, and that's why a lot of times we can't answer their questions. So.
Yeah, in the whole legal area, TREC has created a new working group. Actually, they created it last year. And it's called the Unauthorized Practice of Law Working Group. Because agents continue to do things that they were guilty of practicing law. And so kind of as a result of that, TREC has made us more and more aware that we do need to very often say to our client, you know what? You talk to an attorney, legal advice. Marcia, right, we need to explain to them why we're doing it. It's not just a CYA on our part where we're just covering our assets. It's one of those situations that it's not good service to them. We don't have the authority. And we need to be absolutely clear, because sometimes the way I talk about things misleads people. I am not an attorney. I have from time to time find myself talking to an attorney. And I go, wait a minute, went to college, graduated from law school. You passed that gosh awful state bar exam, which is terrible, and you're still stupid. We got attorneys out there who are clueless about our contract. They're really good divorce attorneys or estate attorneys or what, but they have no idea, and they give really bad advice. So that's why when we're going to give names, when here's what you need help with, and here's how we want to take you down that direction. But it's an important point, and you've got to develop a script kind of along like what Mark's talking about, so that when you're sending them to an attorney or giving them some names, they know that this is because we have fiduciary duties to them. We're operating at the highest level of service and providing them that information. And here's what they need to do. Most of our good attorneys will be fine with having a conversation with them, listening to them about their circumstances, and we'll be able to tell our client, okay, based on what I know now, here's what I could do for you, and this is what it'll cost. Because if they have to do anything, sometimes like even write a letter or contact us or something like that, there's generally going to be a fee. I tend to do that. So, but they'll at least have that conversation and say, okay, here's the, occasionally, depending on the nature of it, they may help us out pro bono because of the relationship. And certainly we would hope that our title company attorneys will work with us on that too. It makes semi-good sense. But yeah, let them know. And by the way, it's not just attorneys. When you say, well, you ought to have a roofer come out, HVAC come out, Ms. Marsh points out, we don't want them to feel like we're just passing the buck. As you work through the thing, we know we have problems with agents saying stupid things about the property and the condition of the property. You cannot represent the property on any level at all, but they do the other thing as they go through the process. They're so conservative. They're so careful not to say anything. Is that, that's some kind of roof issue. I don't know what it is. You need to call a roofer. Well, maybe it is, maybe it's, but you need to have a good script to go along with that so they'll see that you're still supporting that. Now, we've delayed long enough. Joe's wisdom. What do you think, Joe?
I'm gonna follow up on that. One of the reasons they made paragraph 11 so small in this newest contract is because of that, because agents wrote all kinds of things in there. But one other point I'll make on that is sometimes you have a buyer wanting to put certain things into the contract that you don't feel comfortable doing. Have them send it to you in an email, then you can put it in there. Buyers and sellers could write anything they want in those contracts. We can't. And they could cross out anything they want. Again, we can't. So if you have buyers or sellers that want to make changes to the contract, have fun. That's all.
So let's flesh this out a little bit. Joe is semi-right. You really open it up there. The most important part of this is we need clear written instructions from them. It can be an email saying, here's what we want to do. Now, if they're wanting to put anything in special provisions or an addendum to the contract that affects the legal rights of the parties, while they legally in Texas can do that language themselves, it's generally a bad idea. They need to have some legal advice. We need to tell them, they need to operate an advice of counsel. They don't have to do it. What we then have to follow up and say, no, I know exactly, I've done this before. I'm gonna do this. It's not a problem. I tell you, I use escalation clauses all the time. Here's what we want to say. You have got to, in writing, make sure you're on record that you advise them as legal advice as you work through the process. And you also need to see this as one of the first red flags. Whether or not you can continue to represent that client. Because one of the things you need to remember in the real world, if they get sued, so do we. And so anything you're going to do that might affect the legal rights and moves us past that situation is very risky. But you're right. They can do anything legally. They, as Tommy Thompson sometimes points out, contracts, y'all were in the gets it. Yeah, we can write them up on a napkin. Yeah. When a contract gets to the judge, the first thing he has to see is that it's in writing. Judges will not even rule on oral contracts for real estate in Texas. Got to be in writing. If it's writing, he doesn't care what format's in, as long as it's in writing and it's legible. Because the second thing a judge always does is, I need to see the meeting of the minds. If I can't see the meeting of the minds, we don't have a valid contract. Because that has to be one of the factors that's there. You can do that on a napkin. It's a bar, through the process. Fill it out, it's legible, sign it. Yeah, he promised to sell, he promised to buy, and here's what it is. So how much more to meeting minds do you need? Sign here. Okay, fine. And so the latitude that Joe points out, that buyers and sellers have in Texas is huge. But the responsibility that we have under the TREC rules, under our license, is to make sure we advise them. We don't ever want the testimony in court to be our client says, I wasn't sure about that language. So my agent helped me out and said, if you'll use this language, then I'll go ahead and put it in there for you. You're hung out to dry. So we want to make sure that it really is their idea and they came up with it and they want to do it. Because if they say, well, I just trust my agent and they came up with work, then not only were we in trouble, it was a bad thing to do, it was bad service. What else? What was that thing you were talking about, offer to contract?
I was gonna follow up on Nick's about the backup contracts. You have to realize that once that contract is signed, the buyer's option money goes hard. He doesn't get it back any longer. On backup contracts. The other question I get a lot of is when does the day start? If you sign the contract today, it's executed today. Today is 0. Tomorrow's deal, day 1. Then you count off from tomorrow. 5 days, 7 days, 10 days, whatever it is. That comes up a lot. Everybody,
So what has to happen, Joe, for it to be a contract today?
everybody better sign and
So everybody signed, does there have to be something else?
you
The
date it.
execution.
You got the extra date, you've got a date in there, everybody signed it. Does there have to be
Delivery.
some communication? Somebody has to communicate one side to the other. That communication is everything.
Yeah.
Everybody can sign off on it and walk out the room, we don't have a contract until it's communicated. And that communication needs to be something that you in fact improve. It's documented, it's something that we say, yeah. One of the late David Fair had a great little phrase, he said, he loved saying it because people misunderstood it, and now I had to explain. The verbal communication of the acceptance of a written offer creates a binding written contract. The verbal acceptance of a written offer creates a binding written contract. He says, what people hear is, oh, you mean we can have binding oral contracts? No. The oral communication of the acceptance of a written offer creates a binding written contract. He followed up, says, problem is proving it up. How do you prove it? He says so much of all this comes to enforceability. How in fact do you prove that this person actually verbally accepted on the project? Because if you don't have that communication, you don't have a contract.
And that was my next one. Matter of fact, this happened just last night. The agent, our agent has the listing. And the buyers, the buyers are actually agents buying his listing. And they negotiated the whole thing, communicated it back and forth. And then a second offer came in and it's better than the original one. He said, what should he do? I said, you got a contract on the first one. You really can't bring that second one into play. It could come in as a backup home. Even though there were no signatures, but it was totally communicated. Plus he's working with other agents. I thought it wasn't a good idea. What's your advice?
So you're telling me that there were no signatures?
Well, you know, like everybody works verbally or
Okay, so
emails.
the concept of offering a contract is a real challenge. And it comes down to what I just said a few minutes ago, enforceability. I cringe when agents are going this back and forth. Text, emails, back and forth, offers, counter offers. Generally, the courts rule that's not sufficient to be in a binding contract. You need actually signatures. Now, if it's the principals in an email can commit themselves to a contract. Principals. But if it's from agents, the agents do not have the authority to bind their client to a contract. So when you've got that, what has to be communicated is you're going back and forth. And when you represent the seller and you get this last offer from the counter offer from a buyer that your seller really likes, and they probably will accept, but they haven't yet signed off on everything. You need to say to the buyer's agent says, you know, based on my last conversation with my seller, this looks good. I'll present it to the seller, and if the seller still likes it, because remember, things can change overnight. Your client could have a whole different scenario. But if my seller still likes it, and if he signs off on it, signs it, executes it, and I communicate that to you, then we have a contract. Until that happens, your buyer is free to go buy somebody else's house. My seller is free to entertain other offers. Because all we have is conversation. That's all we have. And that's hard. Make sure you've got to make that judgment call about how things are going on with your client. What they can and cannot do as they work through the process. Different personalities, different ways, different abilities to analyze information, different commitments. And it's much more important on the seller side than the buyer side. Because while the buyer can enter into multiple contracts to buy, seller can only sell one contract or one house to one buyer. We have one primary contract. We see more than one. We hope the buyers like each other, want to live together, otherwise we got a problem here. You know, you just gotta work through, because here's one of the things that we often do. Buyer makes offer, seller accepts it. Seller signs off on it. Listing agent has it, listing agent communicates to buyer's agent. Seller done it, seller's physically done everything they're required to do, and the listing agent sends it back over to the buyer's agent. Buyer's agent all excited, buyer's agent takes it over to the title company, move forward. Buyer's agent or the listing agent paid it. Got signatures, no dates. Still have a binding contract. We have a problem with the timelines. We don't know when the option period ended because we don't know when it began. As we sit right here, right now, fully a third of the contracts, executed contracts sitting in the title company don't have an effective date. Because people are negotiating back and forth, signing the offer, they're signing and then back and forth, and they never went back to page 8 and dated it. So they never did that. Somebody at title company finally realizes it, calls the agent up, and the agent got to, okay, well, here was the effective date. Hopefully they're on the same page, because depending on what date you finally agree to, you really impact on the buyer's option period. But you still have a contract. Just because you don't have an effective date doesn't mean you don't have a contract. You still have a binding written contract. So that challenge, if it wants out of going from offer to contract, is a real challenge. We had one, got sued, got it resolved. We had the seller and our listing agent made the mistake of using the terrible word, terrible language. She's a top producer. Big. She said to the buyer's agent, "Great, my seller loves that. We got a deal." But what happened 1 hour later? Better deal came in. And the seller took it into a contract with this second deal. And the first buyer said, "Oh, no, I don't think so. We got a contract." Now, complications in the situation, there's always one more thing. Buyer was an attorney. The buyer's agent was an attorney. Of course, they were right for suit and they were ready to move forward. And we had, we went through the process, had it resolved because and our agent, I know, I should have said that. Yeah, you should not say anything like that, because if it leads the other side to believe they're in a contract, their offer has been accepted, you've got a problem. Because even though they were wrong, they weren't in contract, they were wrong. When all of a sudden attorneys start sending demand letters and work through the process, you got to send that demand letter, copy that demand letter to our E&O insurance. So we start that file going and got that coverage in case we end up with the next step. Janet?
So one thing I just instructed my coachees today is if you're sending an offer back to the other side for final initials, I instruct in the email to that agent, go ahead and execute. If everything's signed, because that's how some of those get missed, is I get it back from the other side.
Yep.
I don't
They don't
check
have all the
it
dates.
sometimes. They don't have anything executed.
Haven't signed, haven't initialed everything.
Well, no, everybody's initially thinks the agent themselves doesn't execute it.
So now we end up with some.
So now I'm instructing on the other side, because their side's the last side to sign, is go ahead and execute, then send me the contract.
Yeah, a lot of them still,
Do what?
a lot of them still won't listen to you say that.
Oh, yeah.
That's okay, but they were still given it in writing that.
At least you're trying.
told to do it.
Yeah. And so in those cases, I put the execution date on it and I copy it back to them.
Yeah.
And I say, hey, here's, because it was executed today, here's the date, just want to make sure. And we're putting this on the title as well.
Okay. But yeah, follow up.
Well, just something that we're seeing in the coaching program is, a lot of our great new agents speak many different languages. And so when we're working with foreign buyers that are out of country and they're asking their agents here, just go find us deals.
Yeah.
Number one, we don't know what that means. Number two, we don't have anything other than Spanish, I believe, for the contracts.
Vietnamese.
For
And for illustration purposes only.
Yeah, to be able
Not be
to
a binding
explain
contract.
to all these different languages, what the contract reads and or how it even translates.
In Texas,
What do you say?
all contracts have to be in English, to be binding contracts. Any documents recording public records have to be in English. You also have a document in another language, you have to have the English equivalent that's recorded along with it. And that's just the law in Texas.
So
So-
how do they fully explain our English to whatever language
And
is?
so here's something that you really need to understand.
Because the buyer can't sign it if he doesn't understand it.
Here's a huge part of your job. Several here.
Not me.
Not you, behind you, okay? Yeah.
It's not me.
Although sometimes your language is. So here's our challenge. You have limitations. What you can do, but your client trusts you to understand their language, what they're saying. Many of your clients in other languages cannot read our documents. They cannot read the English document. Now, we have through Netris, we have some other language, we have Vietnamese, we have some other languages, we have documents through Netris and some other languages. And that's expanding a little bit. But they're trusting you, and what you've got to do at the same time you take care of them and service them is help them understand your limitations. And what you've got to somehow find are interpreters aside from you, such as an attorney who speaks the language or someone else, an adult who speaks the language, can help, work through the process so that they can come up with a better understanding, because, they're trusting you to know the market, to be able to find a good deal for them, to work through the process. And when they're signing off on those documents that you send them, DocuSign, they don't know what it means. They truly can't read it, they don't understand it. So they just trust you when you send them, says, okay, here's where you sign. And they do it, and they think they bought a house, and they go through the process, whatever it is. It's harder. You've got a higher level of responsibility when you're dealing with any client who is not fluent in reading English. It's more than just being able to understand, verbally, but reading it, because they've got to understand that document. And it's a challenge. Imagine, for some of you, it's fairly recent, but when you went through your courses to get your license, what if you didn't have anything in writing? And everything you learned was just what the instructor said? Think how hard that would be. Well, look what your clients deal with. And that's a challenge. You work through it. So you've got to be able to work through that at a level that really helps them understand it. That is a challenge. Yes, ma'am, question.
Yeah, if my point, right now I find, I kind of have a lot of situation like that. The client, because they don't understand English, so they always say, okay, I trust you. Tell me, sign, where, don't say that. So right now I figured out the other part. I find out the one about translation app. And then they're really good. They can just take a photo and all page translate to Chinese. So the whole.
See, if you've got that, where they can now read it for illustration purposes, and they've got a better understanding of it. Now, one of the things that you know, and they probably know, is that you don't have a word for word translation from one language to another. That it's the concepts that we've talked about. So they understand the concepts of what they're doing. Fortunately, as you look through it, some of the big blanks like the price, closing date, things like that, you've got some of those in there. But if you've got the ability to find through apps in today's technology world, I'm glad that you were provided for illustration purposes, making sure that they're working through that, but that the final contract they're going to sign is going to be in English. And they need to recognize, they need to accept that responsibility, because we can't get around that.
Because I don't want to talk to them, take it like.
You can't, because see, now, the direct contracts, if you're fluent in their language, you can read through the direct contract, read it in English, and then translate the concept to them of what's in the direct contract, because it's a direct contract. You have the right to interpret a direct contract and say, here's the concept of what this means. Recognizing there are going to be some limitations even on concepts. You're going to have to say, well, what this really means is, so you got to make some judgment calls here. But if you're fluent in that language as you work through that, yeah, you can really do that. And in fact, that's probably a real plus as you work through. You're able to do that. China?
And on the end, the buyer goes ahead and signs the contract in English. Turns out later they don't like something that was in there. Is the liability on the agent, or is it because that
No.
individual chose to sign
Okay.
the English contract?
That just brings up a really good point that says, Bob, we need a new form. If you, seriously, if you have a client who does not read or understand English, and you're gonna help them with the language, we'll need a form in which we advise them. There's not a word for word translation, even in concepts, and they are accepting the limitation of what we can do for them. And that if later they find a problem on this contract form they're signing, that they indemnify us, that they accept that, you know, we couldn't do anything about it. They accept that limitation. So I'm gonna have to work on the language for that, but I think for our clients, our agents who have clients who have that challenge, I think we need them to accept our limitations of what we can or cannot do for them, how that works. I think that's a good thing we need to do.
Are we supposed to get it interpreted by law?
We can.
I'm supposed to, like, somebody's,
Yeah.
you get them, somebody speaks.
Yeah, so this is an ADA thing about dealing with disabilities. As long as we have advance notice, have an interpreter, yeah. For almost every language except New York, I mean, yeah, who knows that, I mean. Okay, now I want us to go, you've got a page here that has the 6 questions on it. So I think our 4 panel persons up here, yes, sir, Nick has to follow up.
Well, one of the questions on there was, are these documents and handouts available online anywhere or?
Or what?
We can put them on the internet.
What document?
Oh, yes.
Yeah.
The people online.
Sure.
Although.
Yes. But that's not to everybody that they got on, but.
Yeah.
Double check with Lisa.
Okay. So right top says hotline question procedures. And it tells you number to call. And you've got on this thing here, it talks about how it all works. Call the hotline and you go through the process. Is there a follow-up on a procedure of what you guys normally find that when they call? And is it normal that if they call, they'll get you first off and be able to talk to you?
If I'm there, yes.
Yeah, so if they aren't able to get you, what's the process of leaving a message and email or getting back? What's that procedure?
Well, I'm allowed to rules, right?
Yeah, if somebody doesn't pick up, it goes to a message that goes out, the outgoing message tells them the procedure. And they can still leave a message on that
So if you call and you don't get someone, it'll send you to voicemail, which will tell you the procedure for you leaving a message and someone getting back to you.
And a transcription of that voicemail and a link for us to listen to it will come, and I disperse those to whoever's on call.
It doesn't usually, the voice doesn't look at
That's why the link is there so you can listen to it.
Okay.
But the thing is, when you do leave a message, make sure you're around to receive the call back. And that's what I find, you know, you call back and nobody picks up at the other end. You know, it drives you crazy. They got to play.
I try to text and say, hey, this is Nick, because I'm calling from a different number than what they're calling.
Right.
So, hey, this is Nick, I'm gonna, it's now a good time to call you back from the hotline.
Okay, so let's look at these on the hotline questions. You got 6 questions down here. The concept of these questions is ask yourself these questions before you call the hotline. This will make your question for the hotline better. And it will help us be able to answer you as you go through the process. So, Nick, tell me why question number 1 is valuable.
Our advice changes
Yeah,
depending on who you represent.
you guys have gotten really good at that. Almost every time when you walk in, say, okay, Bob, I represent the seller, then you ask a question. Occasionally you don't do that. So my first reply back to you is who we represent, buyer or seller. Because it does. Depending on who we represent, our answer will change as you work through it. So
significant. So Marcia, what about question number 2?
Well, if we're in a contract, it's legally binding, not us, our clients. It's legally binding versus an offer is just still a back and forth type of conversation.
So the different set of rules. Remember, in an offer, nothing in an offer can require anyone to do anything. And only the parties to the contract can be required to do anything. So the buyer could say something in the offer and, they could say, no, we want you to do da, 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 and you're not required to do it. Confidentiality, for example, you're required to treat this offer confidential. No, I'm not. Just ask me to do it, doesn't do it. That doesn't make it work. So the rules on offers are entirely different than contracts. Because when we talked earlier, you can rescind an offer, you can't rescind a contract, you have to terminate a contract or whatever you want to do. So, Scott, number 3, what do you think?
Well, so I think you just have to ask yourself, what is the question I'm trying to ask? And is it something that's already addressed in writing in a contract or an addendum? Because a lot of times you already have the answer. You just have to figure out where it is. So, but sometimes it's not addressed in the contract, and then it's more of a procedure, or a strategy, that type of thing. But always go to the contract. We learned that from Bob. What does the contract say? It's like, dang it. So always go to the contract first, always go to the addendum first, then read exactly the sentence, because 75% of the time your question is already answered.
So a good example of a procedural question, dealing with the offering process or anything like that, but also a listing. You're on listing presentation, you take a listing, and your seller wants to change some things in the listing agreement. That's a procedural. Now, our policy is on a listing agreement, on the last page, you get to sign that for us. You have that authority to do it, provided you've not changed any of the text or you haven't put something really funky in special provisions. If your seller has changed some things in there, that's a procedure question, and you need to call out and says, okay, here's what he changed. He changed this part, this paragraph, changed this, that, or whatever. Maybe he took the protection period out or whatever he might have done. So if he makes a change or something like that, then those changes have to be approved by us. You can no longer just sign off on it because it's not the standard text of what we've agreed to as you work through it. And depending on the nature of whatever it is, there's some paragraphs in there that frankly, I could care less. In fact, they take some paragraphs out that really were to their advantage and they wanted to do it. And we see this a lot with attorney sellers and high dollar sellers who go through that process and they, want to. But that's, it's just, you got to take that next step. Now, we can, on our side, we can insert things as special provisions. We can line through things. These are not TREC forms. These are Texas Realtor forms. And we can do it. We can even create language because we are one of the principals to this agreement. We're a party to the agreement. So because we're a broker and the client, we can accept those changes. We can do it, but you have to go through the process, call the hotline, say, here's what the seller wants to do. Is that okay? Is that not okay? And what do we want to do? So that would be a procedural thing. So is that okay? Now, as you kind of pointed out, please read the contract. Please read the document. Now, as big a fan as I am for the language, as you know, I spent 6 years working on the language on the TREC contracts. I think they're good, but I also own up to the fact that there are sometimes language that there's so many possible interpretations that you've read it, you looked at it, you still have questions. That's a good question to ask. And let us know that you've read it. You've gone through and said, okay, I've read paragraph 6D 7 times, and I still don't know what it means. What is that? Following use reg, I'm not sure I understand what that is. So, yes, ma'am.
Yes, this is for the TREC contract. What happened to the builders? They have separate. Can we change the buyer or seller? Change anything in the builders?
Okay, so in dealing with builder contracts, which is
unless the builder agrees to use one of the two track builder contracts, and they can do that if we got to. Most of the time, they're gonna use their own contract. The buyer still has that legal ability to change any language in any contract you're into. It's gonna be harder to do with the builder. Says, you know what, here's the deal, take it or don't. If you don't, next, we don't care. So it's hard to do, but they can. Remember, builder contracts are one of the most dangerous, hardest things we do. Because we cannot advise our client on what the contract says. We cannot advise our client on what the builder's contract says. You know, we can see there's a financing paragraph, we can see there's an inspection paragraph, you see a blank in there. But when you look through some of them, you say, you know what, you really need to have an attorney look at this. Here's a paragraph. I'm not going to advise you, it'd be legal advice. Basically, it looks to me like the builder says, if we still feel good when closing day comes in, we want to still sell it to you, we might. We had a chance, a year and a half ago, we had a couple builders that effectively had paragraphs in there that said that. Because the prices were increasing so much that if you didn't do exactly what they wanted you to do, you're gone. Here's your money back, sell it for 100,000 more than the next buyer. So builder contracts are really hard, and we got to help our buyer understand that. Yes, ma'am.
I'm sorry, to ask you, keep talking. Like, one of my buyers,
What?
he sent me the builder's contract to me. And there was something funny, I go talk to your lawyer. She called the builder, he said, it's fine. So he believed it. I mean, what do I do with that?
So if a buyer does that, if a buyer says, you tell them to talk to an attorney, they don't do it. They talk to the builder, builder says, yeah, here's what that means, and it's okay. They make the decision, send your client an email. I understand that you talked to the builder. Here's what the builder has interpreted, told you. You've decided to believe that. If it moves forward and that's not what it is, you've accepted the risk. You need them to acknowledge an email, which you advise them of the risk, because it is risk. Anytime you're trusting any seller, but particularly a builder or insurance seller, to do what they said they're going to do, that's a huge risk. Because, you know, not only sometimes do they change their mind, sometimes they didn't understand that's what they really thought you understood. Sometimes they just outright lie about it. That's just how you see it. Buyers are liars, will so are sellers. And so are the agents in the other companies, but not us. So yeah, so everybody good with 3? Read it, make sure you understand it. Joe, 4. What do you think?
Well, sometimes we get a call that they don't know what form to use, so we have to assist them with that, but and walk through all the, finding out what's going on, you can tell them what form to use, but the most important thing about 4, as Scott just said, if you have the question and you read the document, you know which document to use, and you read it, you're gonna answer your question 99% of the time. You don't need to call us. But sometimes you're not comfortable and you call us and we tell you, yeah, fill in these blanks or whatever, and that's it. But really, if you read these documents, they pretty much are self-explanatory.
And you're right. If you do that, it really changes it changes your question. I had an agent, because we talked about this in previous classes. And she came to the door and said, Bob, I had a question for you. But on the way to see you, another agent asked me that same question. And guess what? I knew the answer. And so I didn't need to ask you, because if you think about the question and go through and analyze it, you'll find out you already know the answer. And so when you go through that and you finally get someone on the hotline, you're going to find that, hey, it's a better question for you. It helps us as we come forward on the answer as we work through it. And then question number 5, I'll do that. If this is a procedure question, have you clarified what your client wants to do? Now, I understand that before you start advising your client on something, you want to understand some things a little bit better. So I just wanted to make sure that I understood all the options that my client might have if they want to terminate the contract or amend the contract or ask the seller to, or ask the buyer to release earnest money to extend the contract. I understand. I just want to understand all the options before I talk to my client. And I understand that, but what you really got to understand is you probably know, because of your interaction with your client, unless it's just a really quick interaction and you've only worked together for a couple of days, you may not know, but most of the time you know what your client's gonna do. And by the way, it doesn't help me. It's not a good answer. We say, well, I just want to buy the house. Well, that's not a good answer. Let's talk about how we're gonna do that. Let's talk about what our challenges are as you kind of work through that. But if you've got a question, say, well, you know, and say, well, my buyer wants to extend the closing date, because they can't get financing by the closing date, so what do I do? That's a procedural question. So if your buyer, if you've got a closing and it's supposed to close this Friday, the 19th, and your buyer says, you know, I got some financing issues, so we need to extend the closing date. And if you call the hotline and says, so my buyer wants to extend the closing date, what do I do? It's not a good question. First of all, we know we have a track promulgated amendment form. Item number 3 is extends the closing date. So one, that's how you do it. Second is, what's behind it? Well, this buyer needs to change the closing date. And here's that several layers of variables as you work through this. If this is the 3rd or 4th time your buyer has done this, you better have a really good story. Part of it may be that you're going to have to get your buyer's lender to talk to the seller. Hey, this is a great buyer and here's what's happening. It's all technical. There's no problem. You know, we got done and here's just the little thing that has to be done. Maybe it's even something that the seller has to do, make this thing finally happen. But you know, the actual process is that you need to know the stuff behind it. When your buyer needs to do something like extend the closing date, you should have the big picture. Is this a vacant property? So possession is not a real big issue here. Or this is a situation where the sellers are moving out this weekend, expecting to get the money to be able to move to New Jersey or whatever like that. And so if those are the circumstances, then you've got to work through the process with your buyer, different situation. So you need to look at what's really going on as to how you're going to advise it. And you know that, you already know vacant property occupied when the seller's moving out. Seller's going to be there for another 30 days in temporary lease. So possession is not an issue. So all we're working on now is the timing of the money for the seller and timing of the money for the buyer. And if you've got a buyer, and the most common reason for buyers have to extend closing is financing. If you've got a buyer in that situation, make sure you had a really good conversation with the buyer's lender on what's going on here. Because if we keep hearing one more time and I say, oh yeah, I'll maybe see one more. Some more time sells it, you know what? No, not reasonable anymore. We're ready to move on. So you kind of work through that. Why in the world, question number 6, why do we need to know who the other agent is, who the lender is, the title company inspector? Why do we need to know all that?
Know how much to drink.
There are a couple of answers to this. And you need to work on this. Just frankly, as great as you guys are, you're not good at this. When you come in to see me and you've got a question, a situation, depending on what's going on, very often early in it, I'll ask you, okay, so what title company we dealing with? More importantly, who's the agent on the other side? RE/MAX, which RE/MAX? I need that information. Now, why do I need that information? It makes a huge difference. Marcia?
Because you may have a relationship.
We have a relationship. I just had one happen and the agent on the other side was with RE/MAX DFW. I know his manager really well. So we're working together. We'll have a good conversation moving forward this year. Yeah. So hopefully we got this worked out. We got the amendment. We got to say, okay, good. Because it does make a difference, knowing who it is. Now, I will tell you, and I'm not going to name it. This is a recording, may go on YouTube or something. There is one brokerage out there, it's a small brokerage, fortunately, that it will not be any help at all that I'm involved. Because the broker in that little company has actually sued me in relationship to a code of ethics violation that I sat on the panel and we ruled against him. And he accused me of bias and sued me. We've got a terrible relationship. So me being involved, my name coming up will not help the situation at all.
Yes.
Oh, I can't tell you, I can't give a name. So that's why, when you bring me a situation and I ask who it is,
That's why.
that's when we'll have that conversation. I say, oh, oops. Can't help with that.
Sorry.
But it is, do I?
I said, if you tell us, then we'll know.
Well, I will tell you, but I will tell you when you come, but I won't tell you here because it's recorded. Because you know what, this is the kind of, what was
Things
interesting,
have changed.
this guy was a scary moment. When we went to deposition in this lawsuit. And fortunately, because it was a Texas Realtor, Russell Sanders, all that stuff, they actually were a friend of the court, and they actually, one of the Texas Realtor attorneys represented me going through the process. Well, in the deposition, he asked me if I ever in class made a statement about how I have a general tendency to be anti-authority. And I do. I've had that statement. I've made that. What scared me is that he knew something I said in a class. I don't know whether it happened to be a coincidence that one of his agents happened to be in one of my classes and I didn't know about it. But that was a little scary that he had that kind of information in that lawsuit. I said, wow, it's kind of sneaky. But we need to know, title company, lender, inspector, we need to know all that. It really helps us answering the question going through contract. And to the final point is, just like they can help you, because when you got a hotline question, they may have just had it. Maybe I just had that same thing last week. So they're in a better position to work it. Same thing in my case. If you bring me something, I said, wow, I just dealt with that. We just would do that. Something that we haven't had here, that I've had, we just had our fourth one in Rockwall, fraudulent sellers. All four are dealing with acreage. We do quite a bit of acreage out of the Rockwall office. Fraudulent sellers. One of them actually went all the way to a contract before it finally recognized it went through the process portion did before closing. So we're seeing that. So if you get into any farming ranch and acreage deals like that, be extraordinarily careful, call me, because we've got some real red flags that we're working through and dealing with kind of that situation, but just work through it. So please, 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 Becky, if you have to make something up, do it. Call the hotline. Tim earned your big bucks.
On the weekends. I haven't thought.
Any final good questions that Zoomers have or that you have for our fine? And I really appreciate them taking time out of their business to be here. Let's give them a break. Last minute good question. Zoomers, you have anything? Okay. Guys, yes, ma'am. Shirley, what you got?
Speaking of Zoomers and recordings of your classes, are all your classes usually on YouTube?
It's recorded.
Is Zoom and it's recorded, is it, how can they access it?
It's on our YouTube channel.
On YouTube? So we record all of it. Okay, perfect. That last one I did on procedures, you need to, on that, deal with the pyramid procedures, is really important thing. Can I see? Yeah.
Yes, a quick question. The rental of the property. If the arts, do you have any the day the period day to the landlord to pay back the deposit?
Every day.
3 days. But if he's say, there's a broken window and he has to replace it. You've got to document that and take it off. So let's say it was $1,000 security deposit and it costs $100 for the window, he sent it back.
You got to document exactly what he removed on the security deposit before he sent it back.
Anyways, that's important. It's the 30 days. The 30 days can change if that tenant doesn't give you an address.
Don't give a foreign address.
Right.
You can send it to him.
And then
But it, you know what? It took 3 guys to even start.
It's good to send certified. It's 3 of us. This way, he's always covering all his bases. Like if he's giving nothing
I'm
back,
just trying to rack up points here.
that big, then he should send all the documents in certified mail. This way he knows they've seen. No problem.
Yes, okay. The guy bought the house and he turned it out. But they got- They're also. So you can list it. The first deals.
Frisco, the location.
Okay. So we may get out of that.
Just.
That's okay.